Please note, this podcast contains mention of child sexual abuse. In 2015, the Independent Inquiry into Child Sexual Abuse was set up to investigate where institutions fail to protect children in their care. The inquiry's final report, published in October 2022, laid out a set of powerful recommendations to address past failings and protect future generations of children from abuse. Recommendations for Change is a 5-part podcast series from NSPCC Learning, examining why these recommendations are needed, how they'll work if implemented, and what impact they will have on the prevention of child sexual abuse. Episode 3: Children in Care. Children in care, or looked after children, are a particularly vulnerable group. Many young people enter care because they have been abused or neglected, and looked after children might move in and out of care or between care placements frequently. These experiences can leave children with complex emotional and mental health needs, which can increase their vulnerability to abuse and exploitation. The Independent Inquiry into Child Sexual Abuse found that, rather than being protected, many vulnerable children who entered care were subject to further abuse. In this episode, we'll be looking in detail at the ICSA findings relating to children in care. To kick things off, I spoke to Claire Sands, Associate Head of Research at the NSPCC, to get a clearer understanding of the demographic of children currently in care in England and Wales, as well as their additional needs and challenges.
Well, the number of looked after children has been increasing year on year since 2010. In the year ending 31st March 2023, there were 83,840 looked after children in local authority care in England. And this increase in demand has coincided with a reduction in funding of public services, including children's social care. We know from the data that the majority of children are in care because of abuse and neglect. The latest figures show that 65% of children in care in England and 61.5% in Wales were in care for these reasons. And in 2023, roughly 1 in 10 children in England and Wales experienced high instability in care. And this is when they have 3 or more different care placements in 1 year. So they're moving around a lot. And placement instability can have a detrimental impact on a child's emotional well-being and mental health. It can also prevent them from forming stable relationships with the adults who could help protect them. Children in care are more likely to have suffered hardship and trauma than their peers, and they may display challenging behaviour as a result of their experiences, and some find it hard to develop positive relationships with their peers and to trust adults. They're also more likely to go missing than children who are not in care. In 2023, missing incidents were reported for 12,740 children living in care, and almost 2/3 of these missing incidents related to children who were in residential settings. Children might run away for any number of reasons, including to escape sexual abuse. A thematic assessment of ICSA Truth Project accounts found that 24% of children abused in residential contexts ran away. These factors, including the absence of peer and adult support networks, previous experiences of abuse and neglect, and increased likelihood of going missing, mean children in care are much more vulnerable to sexual abuse and exploitation.
During the course of their investigations, what problems with the children's social care system did ICSA identify that impacted the safety and well-being of children in care?
ICSA reported that institutional settings, including residential care, were prone to failures of leadership, a lack of concern for the welfare of the child, and inadequate and sometimes wholly absent child protection arrangements. The inquiry found that institutions sometimes prioritised their own reputations above the protection of children. Senior people in many of the institutions studied by the inquiry were rarely held accountable for sexual abuse that had occurred in their own institution. Power imbalances were exploited in some children's homes, where some staff treated children as undeserving of protection from sexual abuse. And there was evidence of victim-blaming language in almost every institution, and this went largely unchallenged. In some areas, children who were from ethnic minority communities were subject to racism by care staff. Across some institutions, there was little recognition that children with disabilities were more vulnerable to being sexually abused. And the physical environment of some care settings, such as those with unsupervised outbuildings or extensive grounds, presented opportunities for sexual abuse to be perpetrated. Residential care in the 1970s and 1980s carried little priority with senior managers and local authorities, even when they were made aware of escalating numbers of allegations of sexual abuse. Many institutions knowingly retained in their employment adults who posed a risk to children. People classed as volunteers were often allowed open access to children in care without any vetting, and in some instances, a sexualised culture existed in residential homes. Although standards of conduct and child protection procedures were frequently put in place, staff were rarely trained in their use and action was not taken against those who did not comply with those standards. In the 1980s, there was additionally evidence of failures to vet foster carers properly for their suitability to look after children. When allegations of sexual abuse were made about foster carers, some councils were too willing to disbelieve the child. Indeed, complaints of abuse made by children were rarely listened to by institutions and were often dismissed without investigation. Strengthening the safeguarding systems within children's social care is a continuous task, and it's vital that we learn from ICSA and implement their recommendations.
The ICSA final report makes clear the need to enact changes that create a safer environment for children living in care. The final report refers to a patchy and incomplete regulation of professions working with children in England and Wales. To find out more about how children's homes are currently regulated, I spoke to Patricia Cannon, a solicitor and head of family and childcare at law firm Simpson Miller.
So there is a Children's Homes Regulations Act, which is from 2015, and it sets 9 quality standards for children's homes. I'll just detail a little bit of the standards that it sets. The first standard is the standard of care, quality and purpose. So the idea around that standard is to address the needs of a child from a physical, emotional and psychological perspective. And it's intended to promote growth and development so that it meets the particular needs of an individual child. Then there's also the Children's Views, Wishes and Feelings standard. It's designed to allow children a voice in decisions about their lives. It's set to allow children's opinions to be gathered and they should be listened to. There's the education standard, which requires suitable education provision to be provided to a child. There's the enjoyment and achievement standard. This is to encourage and foster positive relationships. Often children who are in children's homes don't have support networks. They've arrived from very difficult circumstances. And this is intended to help them develop their social skills, their emotional resilience, and also to help them develop a support network. There's the health and well-being standard. This covers emotional and physical care and should allow for access to mental health services as well. There's the protection of children standard, which addresses the importance of providing safe and secure living for children. And that should also cover the vetting of staff that work with children. And there should be processes for incident reporting and protocols for emergencies. The idea of the standard is to ensure that children are protected from harm and maltreatment. There's the leadership and management standard, which addresses the need for management structures to be in place so that there are skilled people working with children, maintaining high standards so that children have a consistent experience of the care that they are given. And then there's the care planning standard. This covers the needs for personalised care for children. So it would promote bespoke planning to help young people to develop opportunities for their future as well. The children's homes is inspected by Ofsted and it can assess those criteria which I've just described. Those are the ways that children's homes are regulated.
And what are the regulatory requirements for people working with children in care settings?
Sure. So for those working with children in children's homes, they should undergo a criminal records check before taking up a position. It's described as DBS, which is the Disclosure Barring Service. So the idea is that it would reveal if someone is barred from engaging in regulated activity, for example, working with children. There are also regulations which set out information which an employer should check as to a person's suitability to work in a children's home. For example, proof of identity. They would need the DBS certificate, references, verification as far as possible as to the reason why they may have left their previous employment or why their position might have ended. There should be documentary evidence of any qualifications that the person has that are relevant to the position, as well as a full employment history. And these records should be available for inspection if so required. What I would say about that is that where there is a concern that an individual may pose a risk of harm to children, employers have a legal duty to notify the DBS, for example, when they've dismissed an individual or where there is a reason that that individual has resigned from their role. But despite this, the DBS has indicated that it doesn't receive the number of referrals it would expect to from employers.
So ICSA's recommendations 9 and 10 are about strengthening the use of the DBS barred list. What might this look like in practice?
So supervisory authorities have the power to refer individuals to the DBS so that they may be included on the barred list, but they don't have a legal duty to refer or to share information unless in response to a specific request. So that leaves it a little bit open. And the report that we're discussing remained concerned that individuals were not always being referred to the DBS. So that means that they could move on to a different setting without their risk being properly considered in their new working environment.
The proposals around the DBS that Patricia just explained are part of ICSA's broader consideration of safer recruitment practices. The ICSA final report says that safe recruitment is, quote, a central aspect of keeping children safe, but that, throughout its investigations, the inquiry encountered examples of poor recruitment practice. I asked Chloe Meany, a safeguarding consultant at the NSPCC who specialises in HR and safer recruitment, to provide some advice on what organisations can do to ensure they're putting safer recruitment at the heart of their recruitment processes.
So what we've learned from ICSA is that all of these areas of safe recruitment are vital to keeping children safe, and we have to remain vigilant and maintain a continual learning approach to all the elements that make for a good safe recruitment practice. To help us understand what safe recruitment looks like, it's really helpful to break it down into key areas. So we have the planning, understanding the roles, as well as a really well thought out selection and assessment process, robust vetting, and then all the elements that are required to continually assess suitability, such as induction, trial or probation periods, regular check-ins, and a really clear policy on expected conduct and behaviour and how to manage any safeguarding concerns. I would say a really good place to start for organisations and individuals who have control of these types of policies is to really look at those, look at your recruitment, selection and vetting policy and process as it currently is. And does it include safe recruitment steps? You know, what does that look like? Is it legally compliant? Has it been reviewed with a safeguarding mindset, for example? That's really the key to this. And, you know, going beyond compliance, does it support a positive safeguarding culture? And these are all questions we can explore when reviewing how we are practicing safe recruitment. So it does go far beyond just the criminal record check and the safeguarding messages that we're so used to talking about.
Are there any resources out there that professionals should make use of when reviewing their safer recruitment processes?
There's so much out there. I mean, a lot of this is in statutory guidance, you know, working together to safeguard children. And then there's lots of sector-driven guidance as well that really outlines the basic, getting the basics right. And getting the basics right is fundamental to a really robust safe recruitment process. But what we also have learned from the inquiries is, you know, what we can do beyond the basics. And those are things like incorporating value-based recruitment, and value-based interviewing is an example of that. It's a framework that helps us to ask questions around a person's motivation and attitude in relation to working with children, as well as their understanding of safe practice and professional boundaries. And it's only when we start asking those richer questions from individuals that we can really understand more about them, it always has to be relevant to the role. So I come back to understanding the role and mapping your selection criteria and assessment against the role. So to make sure that the questions that you're asking at selection stage are relevant, but that they give you the opportunity to learn more about individuals and make that really informed decision about their suitability in working with children and young people.
And if you'd like to learn more, we've put some links to different NSPCC Safer Recruitment resources in the podcast show notes. As part of its proposals around regulation of the care sector, ICSA recommends that the UK government introduces arrangements for the registration of care staff working in children's homes, recommendation 7 in the final report. Staff in children's homes are already required to have a DBS check, but registration would enhance the accountability of staff and ensure they are receiving the necessary training for the role. The ICSA recommendation says that registration should be with an independent body that sets and maintains standards of training, conduct, and continuing professional development. This body should also have the power to enforce these through fitness to practice procedures. The registration of care staff in children's homes is already in place in Scotland, Northern Ireland, and Wales. To find out more about how this kind of registration works in practice, I spoke to David Pritchard. David is the Director of Regulation at Social Care Wales, which is the regulator of the social care workforce in Wales.
This recommendation is around the regulation of those who work in children's homes. And it's about whether we think about those people who do that work and think they should be registered in the same way, perhaps, that nurses, that doctors, that a whole range of other professionals are. It's not really within my gift to talk about what the situation is in England, but I can give you a little bit of our experience in Wales, where we've been registering people who work in children's homes for many years. And we have around 3,500 people working in that sector, and they're all registered with us, that is Social Care Wales. And what that means is that when they apply to be on the register, we do a check on who they are and their background, and that gives us a sense of whether they are appropriate. And if they're not, if they've got particular histories, we will not allow them to work in the sector, and that means they can't get a job doing that work. When they become registered, they're subject to a code of professional practice that sets out what they have to do and how they do their job. It's not about the specific tasks, it's more about the values and the approach that they take. If they fall foul of that, then we have the opportunity to investigate and, if necessary, to take action against that individual. We can give them warnings, we can recommend they take action to learn particular things, or at the extreme, we can remove their right to work in the sector. And that's a really powerful contribution to public protection, we believe. It really makes a difference to the public's confidence in the children's residential sector, but it also protects the status and view of the workforce itself, because they know that they are part of a skilled, competent, and suitably qualified group of individuals. But I would say that registration isn't just about public protection, although that is clearly the first and foremost. It also allows us to set standards. It gives us huge amounts of data about those who are working in our sector, and it gives us a way of offering them support and to communicate with them about things that are important. So, for example, during COVID, we were able to give those people really clear and important messages about their practice during what was clearly one of the most challenging periods of our lifetimes. It also allows us to learn information about what's going on in the sector, about the referrals we're getting, and areas perhaps of poor practice that we can feed back into the sector to help them improve practice and avoid making some of those mistakes. So we believe registration is fundamentally about public protection, but it also gives us a wider suite of opportunities to improve practice and improve the safeguarding of children in children's residential sector.
So the registration of care staff can lead to an improvement in the quality of service provision as well as child protection. What other steps are Social Care Wales taking in light of the ICSA findings?
So I think the ICSA report really has set a set of questions for all of us working in social care about what we do and how we work with other agencies. And I think for us in Social Care Wales, that has strengthened our work with a range of other organisations that I think is really important. So, for example, around safeguarding, we have put together training for all those who work in our sector, that they can get the basics of what safeguarding requires. And we work very closely with the regional safeguarding boards that have been established in Wales and the National Independent Safeguarding Board itself to really assess what more we can do to promote safeguarding across the sector. And generally, children's services are clearly under major pressure across the UK, and that's no different in Wales. But we've been very supportive of working with the Welsh Government about a range of initiatives to understand what the issues are, but also to put in place the kind of solutions that might make a difference. But what ICSA has done is really shone a light on the sector and where we can do more to help improve the safeguarding of our children.
In addition to recommendations that aim to create a safer environment for children in care, the ICSA final report also includes proposals to empower children in care to speak out about abuse and, crucially, have their voices listened to and respected. Reform to the legal recourse that children living in care have access to is one area of consideration. As mentioned earlier, children living in care may feel that they have little control or say over aspects of their life. This extends to their legal position. Decisions are made on their behalf by local authorities, who act as their corporate parent and arrange their care plan. And there are limited routes by which children and young people in care can express their views about their circumstances. Here's Patricia Cannon with more information.
When a child is in care, they can make a formal complaint about their care. There is a mechanism to do that. For example, they can, if they had the resources and the skills to do so, they could make a complaint to the Children's Commissioner or to a local government ombudsman. But it doesn't change the position of the children in care. There are limited routes by which children in care can try and raise concern about the care that they are giving. They should have access to advocacy provision to make representations that they wish to make. It would be in limited circumstances, really, that children would probably feel empowered to raise these sorts of concerns, because once they're in care, their network is more limited, and they rely on those around them to be able to help them to raise concerns. And that's part of what this report had to address, was children voicing concerns and not being listened to or feeling that they weren't listened to. At present, children can bring applications under the Human Rights Act 1989. They would normally be represented by an adult acting as their litigation friend, and can conduct proceedings on their behalf. They can get legal aid for those sorts of applications. They can ask for a decision by a local authority to be judicially reviewed, but that's a legal mechanism that is very little used by children. And the child would need to show that the local authority had acted in a way that was illegal or irrational or procedurally improper. These are really high thresholds, so it's a difficult legal route for a child to take. Those proceedings don't put the welfare of a child as paramount importance, which is of paramount importance in Children Act proceedings, where, for example, the parents were involved. At the moment, children also have the recourse of reporting matters to the police. Again, this report reveals that that's difficult for them to do. They're vulnerable. There are issues with them being scared of not being believed, or in fact not being believed. They could also seek compensation under the criminal injuries compensation claim. But again, there would need to have been police involvement. It's quite a difficult one for a child to raise awareness about the concerns that they have.
Recommendation 6 of the ICSA final report proposes an amendment to the Children Act 1989 that will improve children's access to legal recourse. Patricia, please can you explain how this amendment will work if implemented?
Recommendation 6 is, again, an empowerment option for a child because they can make an application to the court. The application can be brought by the child. This recommendation would allow the court to consider an application by a child where there is reasonable cause to believe that a child who is in the care of a local authority is experiencing or is at risk of experiencing significant harm. And what the provision would do would be to prohibit a local authority from taking an act or a proposed act which it would otherwise be entitled to take in exercising its parental responsibility for the child. And the court could give directions. And the change would ensure that vulnerable children at risk of harm had recourse to court about a range of aspects about their care. And it would mean that in raising those concerns, their welfare is the court's paramount consideration, as it is when local authorities bring care proceedings or where parents go before the court in relation to private law applications, which are disputes between parents.
In addition, ICSA emphasises that the amendment should be accompanied by the introduction of procedural measures to ensure court applications are accessible to children in care. There should also be provision for legal aid to provide advice and assist with representation. Patricia raised the important point that ICSA found that some children who voiced concerns around abuse did not feel listened to or were worried that their concerns weren't being believed. One of the ways the report proposes to address this is through Recommendation 13, the introduction of mandatory reporting. This recommendation would make it a legal requirement for certain individuals to report child sexual abuse when they witness abuse happening or when they receive a disclosure of abuse. These individuals will be known as mandated reporters. This puts the onus of reporting abuse onto the caregiver, meaning there would be substantively more support for the child to come forward and disclose abuse when it is happening. Since the publication of the ICSA final report, the government has held 2 consultations into mandatory reporting and what it might look like in practice, and the NSPCC submitted responses to both of those consultations. I spoke to Matt Ford, Partnerships and Development Director at the NSPCC, about the recommendation as proposed by ICSA.
The inquiry reached its position and made its recommendation on mandatory reporting because of the terrible evidence that was found of institutions and individuals failing to act even when they were aware or suspected that children were being abused. And it's just completely unacceptable for adults, particularly professionals in positions of trust, to turn a blind eye to abuse. They have an absolute responsibility to protect children and young people. And reporting abuse is essential. And we would always say that people should speak up if they have any doubt or concern about a child, including through our helpline. So, we're absolutely clear about that. But we don't think that mandatory reporting is a magic bullet that will solve the many problems that were uncovered by the independent inquiry. My caution is that, we do know from experience in other countries that there are issues we need to consider here. It's not necessarily the case that introducing mandatory reporting would improve outcomes for children, not least because it could have unintended impacts on the way that the system works by shifting resources to investigation without necessarily improving outcomes for children through care and therapeutic services. So, it's essential that reporting happens when abuse is suspected. That's how you uncover it. But it's not at the end in itself. So if it isn't introduced, we would be saying that it has to be introduced in a way that's part of a much wider child-centred response, which results in children getting the right support when abuse is uncovered so that they can recover. If we are going to go this route, there have to be resources provided to respond to potentially higher demands for parts of the system, responding to levels of disclosures and reports. Because otherwise it would be an unacceptable situation where lack of resources would be preventing children who are being abused being identified by the authorities. Any approach to mandatory reporting that results from the current consultation has to be based on a clear understanding that everyone has a role and what their role is in protecting children. And if groups of people within our services, people in positions of trust and so on, who become mandated reporters, would have to be also clear about their responsibilities and also be equipped with the knowledge and understanding to be able to see the potential signs and indicators of abuse and to be clear about what it is they do if they suspect abuse. And training for people who would be in that position of being mandated reporters would be absolutely essential. And that needs to be resourced. And I think, lastly, mandatory reporting needs to be seen in a context where institutions are held accountable for how they protect children. And, institutions ultimately are responsible for the people who work for them and for their own organisational record in terms of protecting children. None of what I've talked about should result in children being denied opportunities to engage in safe places to get support. They need to be able to go to safe spaces without fear of always being reported to the authorities. So we would think it would be really important to identify where any system of reporting allows children to have that safe space. For example, when they're engaged in therapeutic work to help recover, or contacting Childline.
At the time of recording, a mandatory reporting duty is set to be incorporated into the Criminal Justice Bill, which is currently making its way through Parliament. And before bringing this podcast episode to a close, it's also important to mention that in February 2023, the Department for Education published its plans to reform children's social care in England. This included plans to work with the sector to develop a national framework for children's social care. If you want to find out more, we've put a link to our Casper briefing summarising the proposals in the podcast show notes. And you'll also be able to find links to 2 podcast episodes we produced on the topic as well. Thanks to Patricia Cannon, Matt Ford, Chloe Meany, David Pritchard and Claire Sands. In the next episode of Recommendations for Change, we'll be looking at online safety. How big is the scale of the online abuse problem? And how do the ICSA recommendations seek to tackle the issue? If you've been affected by any of the issues raised in this podcast, you can reach out to the NSPCC helpline for support. Call 0808 800 5000 or email help@nspcc.org.uk. This podcast series was produced in autumn 2023. All information was correct at the time of recording, but the world of child protection is ever changing. To stay up to date, visit the NSPCC Learning website at nspcc.org.uk/learning.